Builders Country Club Company. For the appellate, Mr. Fraley.
Chief Justice O'Connor, and may it please the court. How much power does the government have to claim ownership over private property? That's the question before the court this morning. The Ohio General Assembly has adopted an eminent domain system, which is designed to ensure that Ohio landowners are treated fairly when the awesome power of the government is used. The stated intention of the General Assembly is set forth in Ohio Revised Code 163.59. In part, it is to encourage and expedite the acquisition of property by agreements with owners. It's to avoid litigation and relieve congestion in the courts and encourage a consistent treatment for the owners. It's also to promote public confidence in the acquisition practices. None of these stated policies were adhered to by the Ohio History Connection in this case. As we know, to achieve jurisdiction in this case, they shall provide a written offer, good faith offer to the owner. The lower courts applied a definition of good faith as being the absence of bad faith. They further went on to discuss engaging in a conscious wrongdoing or a dishonest purpose. Both of the lower courts applied the wrong standard. Bad faith is not found in the statute. The lower court failed to support any of its ruling with cases that discuss good faith within the concept of a statutory definition.
Counsel, isn't good faith defined in the statute?
Justice, it is defined only as it applies to the word good faith. It is further defined by this court in other cases, not particularly within this statute, both other statutes talking about good faith within a statutory definition.
Are we bound by the statutory definition?
I believe we are bound. There is a strict construction, as you know, in all eminent domain cases as it applies to statutory definitions. Good faith in this particular case, the court decided that in the absence of bad faith, good faith was achieved. Now, this court in both Kalin versus Smith and also Worth versus Huntington Bank Shares gave us some indication of good faith when applied in a statutory concept. The court went on to say that in Kalin, for example, that a party may have failed to make a good faith effort to settle even when it has not acted in bad faith. They promulgated a four-part test, part two of which is important in this case. Number two indicated that they must have rationally evaluated the risks and evaluated potential liability. Worth versus Huntington Bank Shares then goes further than that. It basically indicates that in some cases, a lack of good faith is synonymous with bad faith. However, that is not true in all situations, as the court declared. Moreover, in all cases of good faith, the court said in their ruling that a good faith determination must be informed. Now apply that to the case at bar. The OHC CEO testified he was not an appraiser. He did not know what a least fee value was, or know technically to what that even referred to. He then went on to say that he never sought guidance from legal counsel or any other expert to help him understand the appraisals he was reviewing. Please keep in mind that both appraisals were addressed to a seasoned attorney from one of the biggest law firms in this state. Nevertheless, the CEO indicated he did not avail himself of that attorney to find out what these meant. So if we take the two cases that were mentioned previously, he did not rationally evaluate the appraisals, nor was he reasonably informed of the appraisals.
So, Counselor, let me interrupt you here. So you're stating this argument to prove that there was not a good faith offer, correct?
That is correct.
So if we find that there was not, then what happens?
Very good question. The jurisdiction question has to be answered before the court can go any further. Jurisdiction is based on a written good faith offer. If it is found by this court that the OHC did not make a good faith offer, anything after that, the court lacked jurisdiction to hear anything else.
Okay, so if,
Excuse me, how do you reconcile that with our case law, like the Roman decision, for example, which says that subject matter jurisdiction essentially says that these things aren't subject matter jurisdiction?
Well, I believe even in subject matter jurisdiction, if the wrong standard is used, and keep in mind, Justice, that in this case, the court found a lack of bad faith, indicated good faith.
But that doesn't go to the authority of a court, a tribunal, to hear the case. I mean, that seems to be a requirement to appropriate the property, but that doesn't seem a jurisdictional requirement. Well,
it under 163.05, it states an agency that has met the requirements of the section of 163.04 and 163.041 of the Ohio Revised Code may commence proceedings in a court by filing a petition of appropriation. So without that jurisdictional piece, which starts with the toll for accessing yourself to the court system, is by virtue of making that good faith offer, which then vests the court in the ability.
Doesn't jurisdiction go to the power of the court, not the parties?
Well, again, if the jurisdiction requirement that a good faith offer is made, it would seem that is the first analysis the court must discuss and figure out where they stand on that position. In this particular case, the wrong standard was used, and therefore we believe that jurisdiction is not appropriate if, as the previous justice indicated, if there is finding that good faith was not obtained in this case.
So isn't this really subject to an abuse of discretion? I mean, some of the case law you cited said that good faith analysis is generally within the sound discretion of the trial court. It's the Kalane case at page 159. So did you make this argument about jurisdiction in the courts below?
We did, Your Honor, and understand that jurisdiction is an argument that never can be waived, but it was made, and it was made in this way. If the court used the wrong standard to decide the good faith, which again is the toll to get on the jurisdiction road, if they misapplied the standard of good faith, then how is it that anything after that could be found within their jurisdiction?
How is the Court of Appeals in error in not finding an abuse of discretion of the trial court? Because it's really, trial court generally has this sound discretion to make that good faith determination.
Yes, the court erred in basically this way. They essentially parroted the wrong standard for good faith. The appellate court said in their ruling that a lack of bad faith equated to good faith. This also goes back, I think, much into the Norwood case that is very controlling on all eminent domain cases, where a strict construction must be used. If bad faith doesn't show up in the statute, and then the court uses bad faith, which they may have that ability to do so, but if the standard is good faith equates to lack of bad faith, that's not consistent with what this court has said in Kalin versus Smith and Worth versus Huntington Bank Shares.
Okay, Counsel, OHC had two appraisals in this case, right?
That is correct.
Okay, let's assume that they only had the Kuhn appraisal for the $800,000 and they made that offer. Would that have been a good faith offer?
Well, thank you for that. It would, and here's why. As stated in 163.59, The intention of the General Assembly is stated. So how would that comport? One, if there was just one appraisal, the Kuhn appraisal, they would have submitted that. They relied upon it. That's appropriate. If they did 2 or 3 or 5, which a state agency would certainly be able to do, leaving the landowner at a distinct disadvantage. So when you do 2, by the way, the statute contemplates an appraisal. That grammatical part of the statute is covered in Purdue, and specifically means singular. If you look at a strict construction of this case and construing the Ohio Revised Code, when they say and by any definition grammatically, and refers to 1, how can we now say that 2, 3, 5, 10 appraisals would be appropriate? Now let's go back to what the General Assembly intended in that case. They wanted to promote public confidence in an eminent domain taking. They wanted to be fair to the landowner, eminent domain taking. They also wanted to avoid litigation. How would this avoid litigation? If they're allowed, if this court says it's okay to do 2, 3, 5, 10 appraisals, but only supply 1 to the party, wouldn't you have to file in court every single case to find out if that was done? In other words, wouldn't it behoove and wouldn't it be a requirement of the party that the land is being taken from to file that case in court? If they do not, they have no ability, because of the statute, to conduct discovery to get the other appraisals. Now, how can that be just and within keeping of 163.59? It can't be. It can't be reconciled in that situation. So, two problems.
Counsel, okay, so there were 2 appraisals. Obviously, one of the appraisals, the amount was misunderstood. Am I correct on that by the CEO?
The testimony before the trial court was that he did not understand, but more importantly, did no due diligence in trying to understand.
You already made that point.
Yes.
So the statute doesn't say you have to take the highest appraisal. It doesn't, because you just argued that it anticipates only 1 appraisal. So even under the mistaken impression, they did offer the highest appraisal. In other words, they did base their offer on the highest appraisal. And do you have any dispute that the entity that did the appraisal was not qualified to do an appraisal?
I do not have any dispute along those lines, Justice O'Connor, but I would add that in looking at that appraisal, and if we use some of the other case law already cited, they would have had to have made an informed, rational decision. There can be no argument that that was done in this case. There was not an informed, rational decision. Thus,
what are you asking us to write? What is it that you're asking us to write? So when a government entity is engaged in an eminent domain matter and has more than 1 appraisal, finish that. What is it you want us to write?
we believe the test should be clear, that a rational, informed decision must be made, and due diligence is required when this situation would occur. Now, again, let me go back and
Counsel, isn't the forum for determining the accuracy of the appraisal the court? You can take that to the court. You can show that the appraisal was inadequate or undervalued. You can then dispute that and present evidence in court, and a determination on the appraisal is then being made. So why is that fatal here? Because you say that it was an uninformed appraisal, which I would think you're saying it was too low. I don't know, but the forum, you don't start out by saying we're going to, because we don't like the value amount or the process on how they arrived at it, even though it wasn't a certified appraiser. You're premature on that, aren't you?
I don't believe so, and here's why. in order to vest jurisdiction, the good faith offer must be made. If you look at 163.59 in the intention of the statute, Justice, the statute is set up to provide confidence with the public, avoid litigation, promote the ability to acquire land by agreement. All of those are stated intentions of the statute. If this statute is strictly construed, as this court has clearly said it should be, then how, under the conditions that you just stated, if they do not allow us to look at that appraisal during that process, they essentially, we did not know there was another appraisal. So this is not about how much the appraisal was or whether the appraiser.
Counsel, are you saying your clients didn't do an appraisal themselves?
Of course we did after jurisdiction was vested in the court. That does not speak to whether a good faith offer was made. I certainly understand where you're going, that in a valuation trial, maybe all the appraisals get thrown in. But is that in keeping with the stated intention of the statute?
Well, as your time has run out, I want you to go to the second proposition of law and tell me about necessary.
Thank you. The court again used a determination of necessary that as long as it was for a public use, then that part of the statute was met. The problem with that is, in the case of Norwood, the court clearly set out a situation, a test that public use has to be a flexible doctrine. It also doesn't put any minimal standard in that case of public use, that it's clear, and actually page 36 of the Norwood decision, I think, is very clearly put. The court must determine whether it is sufficient for public use and benefit in a taking. The standard that was used in the lower courts was not that. It was only, was it for a public use? They answered that question, yes. It is our belief that you have to go further than that, weigh the public interest as contemplated in Norwood. That was not done. Once that question was answered, Justice, that this was for a public use. Keep in mind the public use. The OHC believes that the authority of 14930 gives them the right to create a public park. It does not. There is nothing in that statute that indicates they have the right to create a public park. Now, given that that statute has to be construed strictly, how can we then get to a public use without any analysis as to whether that's good for the public, whether it's in the public interest as contemplated by Norwood? And when you start with the definition that enables the Ohio History Connection, which does not give it the ability to create a public park, that is their stated intention. Now, why did they do that then? One simple reason. This is and has always been about getting into World Heritage Foundation. We know from Norwood that is speculative. The World Heritage Foundation, the last rounds, there's been 3 out of 5 nominations that have been accepted in the United States. So we know under Norwood that would be speculative as to whether they would get in. So they conveniently switched the argument to, we want this for a public park. Now, if 149.30 enabled that, that might be a much better argument, but it does not. The closest I could find was that it is enabling for a monument. So this would be a 125-acre monument that they seek to do. They don't say that. They say that this is for use as a public park. Therefore, necessity requirement is met without any analysis.
Thank you. Your time is up.
Thank you very much.
Mr. Peterson.
Thank you, Your Honor. Chief Justice O'Connor, and may it please the court. This case is not about whether the country club is owed compensation or the amount of compensation that the country club is owed. Instead, it is first about whether the Ohio History Connection properly initiated the eminent domain process, and second, whether the appropriation at issue in this case is necessary for a public purpose. Namely,
if the Ohio History Connection did not appropriately initiate the process, what does that mean? Is that jurisdictional? Does the court have no
I
jurisdiction?
don't think it is jurisdictional, Justice DeWine, for the same reasons that you were articulating earlier. As this court has made clear more recently, while the term jurisdiction has oft been abused in the past, it has been more careful more recently, say the jurisdiction, subject matter jurisdiction, goes to the power of a court. And no one disputes that a court here has the power, the trial court had the power to hear this eminent domain proceeding. And if you look to Revised Code Chapter 163, there are parts of that statute that confirm that the General Assembly did not intend for the eminent domain procedures set forth to be jurisdictional, at least in the way that my friend on the other side suggests. I point the court to Revised Code 163.52, where it says failure to comply with Revised Code Chapter 163.59 doesn't affect the validity of an eminent domain proceeding. I'd point the court to 163.12C, where it says the court may amend any defect or informality in an appropriation proceeding. And so I think combined with the fact that jurisdiction is a much more narrow concept, and then also the General Assembly contemplated in statute that errors in invoking the eminent domain process are not fatal to a eminent domain proceeding.
So what is the remedy if the state didn't comply, didn't make a good faith offer?
I think, Your Honor, at most you would have a remedy, say you would have to make a new offer, but that really, your question of remedy goes also to a question of harm. And we've never heard from the Country Club in any of these proceedings how they are harmed by their allegation that the offer should have been different. They've never asserted that they would have accepted a higher offer. And for all the talk about the efforts to resolve cases like this and without resorting to eminent domain, the purpose of Revised Code 163.59, the history connection has gone above and beyond in an attempt to reach a negotiated resolution. They made offers.
So are you saying that they have a burden to demonstrate they were prejudiced by the state, assuming the state failed to make a good faith offer? Are you saying they have the burden of demonstrating they were prejudiced by that?
I think so. I think a harmless error analysis is appropriate. And that
would be your burden then.
Well, and we have asserted that nothing about the offer here has prejudiced them. And I think there's certainly nothing in the record to support anything that would show prejudice. But regardless, we don't think that their legal test is right. We think that the history connection did everything it was required to under statute and more. Under statute, under Revised Code 163.01J, Justice Fisher, you had asked about the definition of good faith. It defines good faith as the offer that must be made under 163.04B. And that is
that kind of a circular definition.
I admit, Your Honor, it appears so on the surface. But if you look to what 163.04B actually says, it says you must make an offer based on an appraisal. Your good faith offer must be based on appraisal. The appraisal must be attached to your offer, and it must be provided at least 30 days prior to initiating eminent domain proceedings. And so I think it does seem circular on the surface, but when you look at what 163.04 actually says, it sets out a process. And then 163.041 has a form that you puts into practice what the requirements of 0.04 actually are. And so we think that if you follow the requirements of 0.04, if your offer is in the form prescribed by 0.041, that is a per se offer of good faith. And the courts that have considered this question, City of Wadsworth and Lawnfield Properties, they considered the statute both before it was amended to include an addition of the language of good faith and after it was amended. And both of those cases hold that if an offer is made for fair market value, that is a good faith offer. And we think that is all the statute requires.
Counsel, presuming you get in on the good faith, presuming the offer will get you the attention of the court, let's just say, let's address what the alternatives could have been or should have been or are available to preclude the taking. In other words, the necessity.
Absolutely, Your Honor. And we think that the court can affirm the necessity question for at least 3 reasons. 1, based on statute. 2, based on the country club's answer, and 3, based on the factual findings made by the trial court, which would be reviewed for an abuse of discretion. I'll begin with the statute. Revised Code 163.01H2 states that a public park is a per se public use, and 163.09B1A states that when an acquiring agency passes a resolution declaring a necessity, they are entitled to a presumption of that necessity. And
Well, counsel, what about the authority to even create a public park?
I don't understand that to be properly preserved as a question, but even if it is, there's at least 2 relevant statutes. Revised Code 1743.07 gives the history connection the power to acquire property through eminent domain, specifically refers to earthworks and any prehistoric mound. And Revised Code 149.30, which sets out the duties of the history connection, which are to acquire and maintain earthworks. And so it is undisputed that the history connection has the power to acquire property. In fact, they already own the property here. We're only talking about a leasehold interest. All that the country club is entitled to is operate a golf course. But putting that aside, certainly there is statutory authority to have property of this type. And if you look to what the history connection does, they operate parks throughout the state. They operate historic sites. And so I don't think there can be any dispute that of the authority to operate a park on this property consistent with what the history connection does on a day-to-day basis already. In fact, there is another park, the Great Circle, that is just down the road, and no one has disputed that the history connection has the authority to operate that park. But going back to the necessity question, Mr. Fraley, I understand, has relied on Norwood and says, well, Norwood supports their argument. It actually does the exact opposite. Imagine if the shoe was on the other foot. Imagine if it was the state standing before you and said, we need to acquire property, private property, so that we can create a private country club. And this is a public use that we can use our eminent domain power because of all these economic benefits that would flow from it. This court would rightfully reject that on the basis of Norwood. Norwood said that private benefits don't rise to the level of public use in terms of taking. And so Mr. Fraley's argument is clearly and straightforwardly precluded by Norwood. But you don't even need to get there because, as I said, first, the statute Revised Code 163.09B1A entitles the history connection to a presumption of necessity. If they adopt a resolution declaring the necessity, that resolution is in the record at Exhibit 11. It declares.
Counsel, I believe the country club's brief made the argument that there could have been, I'll use the word compromise. In other words, there could have been alternatives that could have maybe accomplished what the Ohio History Connection wanted, which would be some sort of public access to the mounds. And then the country club's purpose. Is that required, that kind of negotiation?
It is not, Your Honor. That argument is wrong as a legal matter, and it's wrong as a factual matter. As a legal matter, this court and no court has ever held that absolute necessity is required. In eminent domain proceedings, it is considered to be just a necessity requirement is reasonably convenient to the public use. And that goes back to the beginning of the adoption of Revised Code Chapter 163. And that would open the door to someone who says, well, we want to expand the road. And if their absolute necessity argument was appropriate, then someone could say, well, you shouldn't expand the road. You should build a commuter rail. You should buy a new bus. And so the court is adopting a rule here that is going to govern every Revised Code Chapter 163 appropriation proceeding. And so it's unworkable as a legal matter, but it's also wrong as a factual matter. Justice Brunner, you had asked before about abuse of discretion and factual determinations. Here, there was ample testimony that the country club's proposed sharing of the property doesn't counteract the necessity. And if you look at footnote 13 of the trial court's opinion, it said no matter who bears the burden of necessity, whether you rely on the presumption in 163.09, whether you don't, that the history connection had more than carried its burden of showing that this appropriation was necessary for the creation of a public park. And so I'd also want to go back briefly and to the good faith question, because that same abuse of discretion standard applies even if you do not agree with our statutory presumption.
I'm trying to understand your good faith argument a little bit. Yeah, essentially, it seems to be as long as it's based on an appraisal, it's as long as an offer is based on an appraisal, it's in good faith. So I mean, could an agency go out and get 50 appraisals till they found one they liked?
They could, Your Honor, but there are reasons why that is unlikely to occur, and there's reasons why agencies would not want to do that. As long as an agency,
but suppose they got 10. I mean, there may be they can just shop around until they find an appraisal that they like, and that's the only one they have to disclose. That doesn't seem like good faith.
I think it is, Your Honor, because what the question is an offer being made for fair market value? And as long as a qualified appraisal, and remember, appraisers are regulated entities, they are licensed, and so appraisers answer to a higher body. And so an appraiser is not going to go out and do a bad job because their license is on the line. So as long as you have a qualified appraisal saying this is fair market value, then I think that is still a good faith offer. And let me tell you why.
You know, we see tax cases all the time, and you see qualified appraisers that come to broad ranges of values. So I mean it's hard to say, when you have appraisals that are, one's twice as much as the other, they both can't be fair market value. I mean,
You're right, they both can't be.
Responsibility on the agency at that point.
Several answers. If you give me a moment, I'll try to work through them in the most succinct manner. First, yes, you're right. They all can't be fair market value, but that's why we have a valuation proceeding, and that's why those are presented to a jury. Now, your question of could they choose which to rely on? They can, and there are reasons why they may not want to do what you suggest, and why as a practical matter, that's not actually a concern. And then also why that's not an issue in this case. It's not a concern because no matter what appraisal an agency uses, they're going to have to defend that appraisal at an appropriation proceeding. And so if you get 10 appraisals and 9 of them are high and 1 is an outlier and it's low, and you choose to rely on the outlier, well, you're taking a risk there that you're not going to be able to defend that in an appropriation proceeding. And there's bite to that. If you choose a lowball appraisal, the Revised Code Chapter 163.21c says, and if then the jury awards a significantly higher amount, you're on the hook for attorney's fees and for costs. And so, yes, an agency can go get multiple appraisals, but if they lowball an offer, they're going to have to pay much more than just the property, the interest that they're acquiring. They're also going to have to pay fees and costs. And so there's an incentive built in to say, don't go around and try to lowball someone. Offer a fair market value. Otherwise, you're going to be on the hook for this additional expense. And so we would say that there's no rule, there's nothing in law that precludes multiple appraisals, but there are practical consequences and there are things that will prevent that sort of worst case scenario as you posit.
But here, if we accept your argument at face value, what I think you're saying to me is good faith equals in the statute in an eminent domain case, as long as they had a qualified fair market value report from an appraiser. But here, you actually have an individual who says, I'm not an expert. I'm not an appraiser. I didn't know what I was looking at. And instead of asking someone to get advice, he just chooses one to go with. And one is higher. So how is that good faith in the individual or due diligence by the person who's handling this on behalf of the seeker for eminent domain?
2 responses, Your Honor. First, that's a factual question that was resolved in favor of the history connection by the courts below, and we think that should be reviewed for an abuse of discretion. But even so, even if you were reviewing it de novo, there were 2 appraisals here. Both were conducted by qualified appraisals. Only one of them valued the interest to be acquired. The Kuhn appraisal is the only one that provided a value of the leasehold interest. The Weiler appraisal valued 2 separate things. It valued the fee simple and it valued the fee as encumbered by the lease. And so when the history connection, yes, they made a mistake about what the Weiler appraisal was valuing, but when they made that mistake, they actually offered what they thought was the higher amount. And so if you want to talk about good faith, in faced with two appraisals, they thought they were making the higher appropriation. And you have the trial court looked at the appraisals and said, not only is the testimony persuasive that you were acting in good faith, the trial court, looked at these and I also found the one confusing. And finally, I would point out that the country club wants to do some math and calculation, say, well, if you subtract one thing from the other in this Weiler appraisal, you'll see that the value is actually higher. Well, you can't do that. Among other things, if you look at Exhibit 44, it's the Weiler appraisal, and it's page 2, numbered page 2, page 8 of the PDF. There's actually a disclaimer in there that says, you can only use this appraisal for what it says it's for. You can't use the information in this appraisal to calculate the value of anything other than this specific amount. And so I think
I don't want to cut you off, but I really do want to get into one more question, and that's the de novo review that the appellant says that the appeals court should have performed. I didn't see very much at all on the part of the trial court in interpreting statutes. What kind of de novo review could the appellate court have done based on what's in the trial court record?
I don't think de novo review would have been appropriate at all. In the trial court record, just to give you a sense of what's in there, if that answers the question, feel free to follow up. There's testimony from several representatives of the History Connection. There's testimony from representatives of the National Park Service. There's exhibits, including the appraisals, the declaration of necessity from the board of the History Connection. We don't think that de novo review is appropriate because we think that if certainly the factual findings that were made by the trial court are correct, subject to abuse of discretion, and there was no abuse of discretion. We think the legal standards they applied, certainly with respect to necessity, are correct. And if anything, like we said, the question of good faith, we think, is a bright line rule, or at least a statutory presumption, that as long as you make an offer for fair market value as determined by a qualified appraisal, that is good faith. It may not be that a jury agrees, but that certainly meets the threshold statute. Because remember where this fits in the whole context of Revised Code Chapter 163. The good faith offer is just the beginning of a process. And if you have the type of inquiry the country club suggests at the beginning of every process, you're going to extend every eminent domain proceeding. You're going to have essentially a double valuation hearing. That's not what it was intended to do. It was intended to kick off the process, say, this is what we think it's worth, begin a negotiation. Negotiations had been ongoing with the country club for quite some time. And in fact, the History Connection had obtained 2 appraisals prior to the ones that are at issue here. And so the country club can't even say that they were surprised by these appraisals, because if you look at Exhibit 44, which is a letter that accompanied the Weiler appraisal when we sent it to the country club as soon as they asked, it notes that 2 appraisals were already done at the country club's request. And so here we would think that the court below applied the proper standard. We made a good faith offer based on an appraised value conducted by a qualified appraisal. We think that necessity was clearly established both in statute and as a factual matter, so factual and legal, and that the courts below correctly determined both questions. And we would ask this court to affirm, remand, so a jury can determine the appropriate valuation and what compensation is due to the country club.
Thank you. Thank you. Mr. Fraley, you've used your time. You may take a minute. You have to unmute yourself, sir.
I would like to start at the beginning. Thank you very much. Opposing counsel has indicated that how were we harmed? They didn't take the higher number. They wouldn't have accepted the higher appraisal. Those facts aren't in evidence, but I submit to you, if you start off any relationship, legal or otherwise, and you don't disclose a pertinent material fact, i.e. the Weiler appraisal, how is it that any trust would be had within that party? And is that appropriate in the context of 163.59 to avoid litigation? How would we have known if litigation was not ensued that there was another appraisal?
Okay, Okay.
we would not have.
Hold on, let me just assume we agree with you, and we say, okay, they didn't initiate this process properly. You've got to start all over. So they come back, they offer you $1.75 million. Don't we just end up back in the same place? You say no, and is anything different than it is today?
Well, here's what would be different. Number one, if they complied with the statute to inform us that there was an appraisal, allow us to accompany that appraisal, that's part of it. Now, the other part is we would assume
but assume that we dismiss the case and they start again. What will be different?
Here's what might be different as it applies to 163.59. If there is an appraisal, one, and they submit it to us.
Well, we know they have two appraisals, right? So
correct.
Again, just my question is, if we dismiss this case and they start over and offer you $1.75 million, how is that? What's going to change?
Well, what would change, at least at that stage, is hopefully, as happened in the first case, the well was poisoned. Once we found that second appraisal was out there, and I myself found it, the opposing counsel.
The well is already poisoned. So what's going to be different if we dismiss this case and they start over besides delay?
Well, I think in our specific case, we start with a clean slate, start with everybody knowing what the appraisals are. That's number one. Now, I think further for all landowners that come after us.
Again, I just, it would be helpful if you could just answer the question of what's going to change here in this case. I mean, you had the litigation history. You know what the appraisals are. I presume that they offered you $1.75 million. Your client would say no. So what changes if we dismiss the case and they start over, other than delay?
The jurisdictional issue, for one, if they act in good faith, which an appraisal, and they give it.
Okay, well, I just told you they've got the appraisal. The scenarios, they make you an offer based on the highest appraisal. So
at that point, my clients would have the opportunity to review the appraisal, to see if it was appropriate, compare it to the appraisal they've already received.
But isn't that stuff they've already done?
We have never gotten the offer of the Weiler appraisal, though. That's never been.
You've seen the Weiler appraisal. I think they've made you an offer in that amount, haven't they?
They have not. They have not done that.
So the heart of this question is it going to make a difference?
Well,
are your clients going to really look at that other number and there's an opportunity to resolve the case?
Well, it may not make a difference. Of course, that would depend upon the appraisal and the behavior of if they're after that, I were to find that there was yet another appraisal out there, it may not change.
Counsel, then why not just go to the jury and let's figure out what it's worth? I mean, that's the bottom line here. If you're saying you're dancing around the question and not really answering it, you're saying what I'm hearing is, I don't know what we would accept. And if that's the case, are you negotiating in good faith here?
Well, I'd like to certainly think I have, as I've handled it from the beginning. And what I would state to the court on that is very simply, if this started out with a good faith offer. Now, I realize now the well's been poisoned. That was no fault of ours. That was theirs. They should bear that burden, not my clients. But let's take it to the logical conclusion. If a good faith offer is submitted, then it gives us every right that statute implies, that we can accept it, we can reject it, we can do all the things that the statute allows us to do.
Thank you. Thank you, counsel.
Thank you.
Gentlemen, we'll take the matter under advisement. You'll be notified of our decision.
Thank you.
Our second case this morning is 2020-338, the State of Ohio versus Samuel Glenn. For the appellant is Mr. Communal.
Good morning, Chief Justice and honorable members of this court. I would like to, can everybody hear me? I'm sorry.
Yes, we can.
Thank you. I apologize. I didn't realize whether I was muted or not. I'd like to reserve 3 minutes for rebuttal if possible. Again, my name is Tony Communal. I'm the appellant Samuel Glenn, a criminal defendant before the Montgomery County Court of Common Pleas. To begin with, I'd like to address what I think was the initial error of our Court of Appeals, the Second District, in failure to examine the nature of the trial court's order. And by that, I mean, as I'm sure you're well aware, the order itself directs trial counsel to create summaries of conversations that trial counsel had with potential witnesses in the case to provide to the state of Ohio. And those conversations would have occurred during the course of investigation or otherwise interviews in preparation for trial.
Counsel, are these witnesses that you identified, are they alibi witnesses?
Specifically, the written order was for alibi witnesses, yes.
Okay, so do you intend to file a notice of alibi pursuant to Criminal Rule 12 in this?
Yeah, interestingly, there are 2 notices of alibis that were filed. The witnesses themselves, the record shows, were disclosed well before this issue came up. The trial was continued at one point to allow the government to investigate some of the names, but the names had already been disclosed. You'll see, I believe, in one of the responsive pleadings during the paper argument before the trial court, that the defendant didn't claim to be at a different place. He claimed that the alleged victim wasn't there and there were witnesses that were there. After discussion, and this is a part of the transcript record, it was decided that the better course of action was to file a notice of alibi. So that was done.
And did you, in the notice of alibi, provide some degree of specificity as to what these witnesses would testify to? Just that the victim was not there at the time she claimed she was?
Yeah, that information was made clear. Whether it's in the notice of alibi or not, I'm not sure, but it's certainly in the record of the court that there was no claim. In fact, to be clear, because they needed to know where it was that the alibi witnesses claimed to be, that it was at the location of the alleged event.
So your defense is basically this accusation by the state did not happen because we have witnesses to support that the victim's version of events did not occur.
That's correct.
Okay, so isn't it your requirement under Criminal Rule 16 to just identify who those witnesses and tell them what they're going to say, that's what they're going to say?
That's correct. And that was done twice, actually.
So what is this specific part of the order that they're requiring you to have these summaries of the investigation that you oppose?
Yes, Your Honor. In terms of the creation of the summaries, initially the trial court ordered the creation of all summaries. You'll see in the earlier pleadings and arguments about the discovery issue that there were a number of state's witnesses that would only talk to defense counsel. And this created a problem for the state. The state wanted to know, well, what did they say? And you'll also see reflected in the motion to compel the fact that defense counsel did share information. I think as any trial counsel would, to say, hey, they may not say what you think they're going to say, go talk to them. Well, some of those people would not talk to them, and some of the alibi defenses wouldn't talk to them. Ultimately, when the decision came out, and the transcript of proceedings of the initial order of the court is within the record and briefed, but ultimately it was changed only to identify witnesses, but then the consequences were put in place that witnesses could not be called if these summaries weren't created. So the creation of summaries as the order of the trial court and the failure of the Court of Appeals to analyze what that meant relative to a witness statement someone may have, or a videotape of the floor of a hospital or whatnot, and the various items that have been addressed by the court. The uniqueness of that led to, I think, the mistake of the Court of Appeals that what this was a reciprocal discovery issue. It was not. The case, the seminal case of Hickman versus Taylor dealt with exactly this issue. It was civil, but an attorney was asked to create summaries of people that he had talked to, witnesses he had talked to. And in that case, the court in that case said specifically that this is not a discovery issue. This does not fall within the parameters of the discovery request. Specifically that the subject matter of whether it was privileged or not privileged was irrelevant. Whether it was relevant or not was irrelevant, because nothing in disclosure rules would require an attorney to recreate conversations based upon his recall or notes or whatever he had. That would be an unjust interference with the judicial process. In fact, the Hickman case says there's no good reason for that, but there are tremendous reasons that violate public policy as why we wouldn't require that sort of intervention. So in first saying that, I think the mistake of the Court of Appeals in not examining the nature of the order, that it was to create summaries, led to this idea that then they had to pigeonhole it into, well, what sort of privilege was it? Now, in that case, the Court of Appeals decided, well, it was it dealt with a work product privilege. And of course, the court
Counsel, what harm is there that could not be addressed on appeal at the conclusion of the trial should your client not prevail?
In terms of specifically, I would respond in a couple of ways. First, not only the public policy violations that are talked about in this court's own discussion and the majority opinion in Burnham versus Cleveland Clinic, that there can be disclosure orders that implicate interests well beyond, and that the extrajudicial harm that's done can't adequately be addressed. This sort of an order that an attorney go into their mental impressions, their recall, their memory, whatever, to assist or aid the other side, the various public policy reasons, I could list them from Hickman, but they're all pretty self-evident. Now,
is that what the trial court did in this case? Did they require some degree of specificity? All you would have to do is just say, these witnesses will testify that the victim wasn't there at the time she claimed the act occurred.
that was already done. That's already part of the record.
Okay.
What the trial court ordered was the creation of specific summaries as to the nature of the discussions defense counsel had with witnesses. And again, the written order does tailor it to only alibi witnesses.
Counsel, couldn't we deal with that on appeal later if counsel for Mr. Glenn just said we're not going to do it? He goes on trial, he wins, the case goes away, he loses. An appellate point would be that you were ordered to do this and you didn't do it, right? And that you therefore you couldn't put on these alibi witnesses. Couldn't we take care of that on appeal?
No, I don't believe so. And the reason that is because the idea that, first of all matters can be handled on appeal. Whether or not something falls within an interlocutory appeal is based upon different factors than just whether it can be addressed. Addressing this on appeal, first of all, it's a guaranteed appeal. The court order, the trial court order provides for no choice but an issue of whether or not the attorney either does not meet his obligation to zealously represent his client by excluding material witnesses, or violates the principles set forth in Hickman and then Nobles, which later made it out.
In Hickman, there was no intermediate appeal, right?
I'm sorry, I didn't
There was no interlocutory appeal in Hickman. In Hickman, what the attorney did was refused to disclose, was held in contempt. There was no right to immediately appeal that order.
There was none, but there is implicated in the decision that there should be. And it's very hard to find, or at least it was for me, cases which were similar on point. The most recent that's cited in the briefs.
Isn't that because courts generally don't allow interlocutory appeals of these types of things?
Generally, based upon, in large part, judicial economy. If you're dealing with a trial court decision that violates public policy pretty much across the board and guarantees an appeal, that's certainly not serving judicial economy. In the New Jersey versus Tier case, which is cited, which was the same thing.
It certainly doesn't guarantee that there'll be an appeal at the end. I mean, you don't know how the case is going to come out. You might want
Well, certainly no. If the defendant wins the case, yes, of course. But in an effort to protect the defendant throughout, which I think goes into the second part of the argument, which was why it should be treated differently. My first point is that I don't think it matters whether it's work privilege or not work privilege, because it's outside of the scope of the discoverable order. If it's outside of the scope of the discoverable order with the consequences that are set forth in the cases prior, then clearly it should fall under 2505 in terms of being immediately addressed. However, even if it were to be, it's certainly not a finding, as the Court of Appeals found, that it is a work product violation. And the reason for that is it's self-evident. The order is for the creation, at best, the creation of work product. It's actually telling the attorney, you create the work product from the work you've done to assist the other side in preparation of their case. This being a criminal case, to assist in the prosecution of the trial court or the trial attorney's own client, which itself, I think, is against public policy.
What if the attorney had simply said, these witnesses are going to testify that they were with the defendant at a party that night, and that was it. No clients, no attorney mental impressions, work, all those things we talk about as work products.
That is,
and that's the judge. The judge says that's sufficient. It's reviewed at the end of the case. What would be wrong with that? I mean, why not see what happens?
If you look at the two motions to compel filed by the state, they themselves recognize that in fact was done. Discussions were had in which the trial counsel said, here's what these people are going to say. That wasn't sufficient for the state. They wanted to know specifically, they wanted to know specific summaries. So in their own argument, they admit that it's been said. Now, one of the things is the government threatens to call the defense counsel as a witness if this isn't provided. I guess under the assumption that because the defense counsel said, here's what I think they're going to testify to, they've now become witnesses. Well, that is just simply a violation of our principles of negotiation. If we don't share information about cases or what our expectations are, or we feel that, hey, we might be witnesses in a case, if we say, I think this witness is going to say that, then that would certainly have its own chilling effect. I think the order for the creation is the problem, not the order for the disclosure. If there were witness statements, if the record reflected someone had given a written statement or a recorded statement or anything like that, I think actually the law is fairly clear that those are part of reciprocal discovery. It is not part.
Are you focusing only on the creation of documents, or also under Criminal Rule 16J, which the state didn't mention in its briefing, material that's subject to the work product protection? Is it one or both?
Well, if I understand the question correctly, it is in fact both, because while the argument below at the Court of Appeals was this shouldn't be pigeonholed into that specific work product argument, which leads, of course, to an entire discussion about the difference between work product and client privilege and how they might be treated differently on an interlocutory appeal in reliance on Hickman, since this is not within the discovery realm and shouldn't have been ordered in the first place. However, obviously, we have to have a fallback position that even if they were within that line, they are still work product protected from disclosure. Now, I think more specifically to answer your question would be to say that if the attorney possessed a written statement made by a client, not a client, I'm sorry, but a witness, then the work product privilege is waived under the case law, under the rules. But this order does not ask for that. This order asks for the creation, and therefore 16J does prohibit that. So it's kind of the government's end around the rules to say, okay, well, you don't have it, go ahead and create it. I don't know if that answers specifically.
That helps. Thank you.
Our counsel, you've used your time. Thank you very much. Mr. French.
Good morning, Your Honor. Madam Chief Justice, may it please the court. I don't want to oversimplify matters, but it is the state's position that appellant is going into a scope of this appeal that is far beyond what is before this court. The second district did not consider the merits of the trial court's discovery order because the second district found that the order was not a final appeal order under 2505 02B 4B. Specifically, the Court of Appeals found that they were not convinced that the appellant would not have a reasonable and effective remedy on direct appeal following judgment. And so far this morning and in his brief, I have yet to hear appellant offer a reason why that portion of the second district's opinion was in error.
Counsel, let me ask you this. Your counsel on the other side claims that they've already told you what these witnesses are going to say. Is that true?
I would submit that is not true. If that were true, I don't believe there would have been any need to file the motion to compel, and there would be no need for the trial court to have put on this order. What appellant did was file a notice of alibi, which said in essence that on the date and during the times relevant to this case, the defendant was at one of three different addresses and was with, at various times, one of 9 different people. 2 months later, he amended the alibi, the same 3 locations, but added a 10th person. A month after that, he amended the notice of alibi to change one of the addresses and to keep one of the 10 and keep the original 10 people. So at the end of the day, what the prosecution knew is that the defendant's alibi was he was at one of 3 different places and was with one or more of 10 different people.
Okay, does that, what he told you, does that contradict what your alleged victim says, or would that directly contradict?
Yes, that would contradict what the victim said, which
okay,
is
so you have investigators, you have the ability to go out and question these people, right?
They all refused to speak to anyone associated with the prosecution. And during various off-the-record conversations, during emails, there were these sort of hints and suggestions that these witnesses were going to say things that were different or that would tank the case or would be inconsistent with the state's theory. So what the state was looking for was simply some information about what specifically these alibi witnesses were alleging. Were they alleging that they were with the defendant at the first address he gave? Were they alleging he was later at the second address, but one of these other people were there? All the trial court was asking appellant to do was to provide some additional detail, nothing elaborate, Nothing that went into counsel's theory of the case or his mental impressions, just something as simple as witness A would testify that he was with the defendant at this address and the victim was not present.
So you're
Something
just
as
looking
simple
for a
as
higher
that.
level of specificity as to what these witnesses are going to say. You don't anticipate using counsel's statements to cross-examine at trial these witnesses as if they were affidavits or.
I suppose the only effect on cross-examination might be if what is said in the explanation as to witness A would testify he was with the defendant at this address. If that witness testified inconsistent with that, perhaps the prosecution would attempt to cross-examine with possible prior inconsistent statements. But beyond that, no, it certainly would not be an affidavit. It would be nothing sworn under oath. It would not be the witness's own testimony. It was an attempt by the trial court to provide more of a level playing field in the spirit of the rules regarding alibis.
Okay.
Now,
So you're just looking for a higher level of specificity as to what defendant's alibi witnesses will testify to at trial.
yes,
That's
is
it.
all that the trial court had ordered.
And that's it.
That's it. Yes.
Okay, You're
Counsel,
not looking for counsel's written impressions or their assessment of their credibility or anything like that.
No, nothing at all.
counsel, your colleague on the other side mentioned that some people weren't even talked to by investigators from the government. Is that correct?
I do not know if that is correct or not. I do not know.
Well, so these witnesses technically were not unavailable. They just wouldn't talk to you. The ones at least that were talked to.
That is my understanding. Yes.
Mr. French, what's the difference in terms of the 2505.02 analysis on final appealable order? Discuss for me the difference between attorney-client privilege and attorney work product.
Well, the most obvious would be anything that is protected by the attorney-client privilege would be any communications between the attorney and the client, him or herself. In this case,
Yeah, I guess what I'm getting at is framed in terms of why it would be critical to get that issue resolved before a final disposition of the matter. Compare the two.
Well, the attorney-client privilege is a recognized privilege at common law that has been held in a much higher regard and is much less subject to invasion. And once the attorney-client privilege has been breached, there's essentially the bell has been rung and there's no going back. Once that privilege has been breached, there's no reasonable mechanism to cure or hide the breach. The attorney work product has never been held by this court to the level of protection that the attorney-client privilege has been held to. This court held in, I believe it's Burnham, that when the work product exception is alleged, more than just a claim that it's privileged or protected is needed before that theory or that process is deemed so violated that an interlocutory appeal would be necessary. That is why when applying 250504, the Court of Appeals found that the appellant had not offered really any explanation as to why this error, if the trial court's order is error at all, could not be remedied effectively after final judgment. An appellant still has not offered a valid explanation as to why they could not adequately remedy any error that may have occurred in the trial court's order, why that remedy could not be effective post-judgment, which
So
is
counsel, presumably the witnesses would have been precluded from testifying. Is that what you think would have happened had this gone forward?
According to the trial court's order, if counsel had not provided the summary of anticipated testimony, the trial court had indicated its intention to exclude those witnesses. Yes.
Okay, so that's appealable, right? I mean,
That is appealable.
if the defendant loses, that's been known to be appealed time and time again about inappropriate exclusion of witnesses. Maybe, I mean, not necessarily based on this basis, but for a variety of reasons.
Yes.
Right?
Yes.
Okay. Also, the state withdrew its request at some point for this information with the trial court, correct?
Yes, it's my understanding that the state filed a motion to withdraw its request after appellant had perfected his appeal to this court.
Okay. Was that an attempt to not come to see us? Or was that where you genuinely felt you didn't need that information anymore?
I think it was an attempt to get the case moving forward at the trial court level and to eliminate any further delay. This case involved a teenage girl who was allegedly sexually assaulted by the defendant. Those types of cases are difficult enough to prosecute without prolonged delay. And I believe the prosecutor's hope was that it could move this case along sooner rather than later. So yes, I believe the intention was to perhaps moot the appeal or make this appeal unnecessary.
Counsel, is this defendant being held in pretrial detention?
No, I don't believe he is, no.
Okay. But if these alibi witnesses are telling the truth, the sooner that information gets into your hands and you can assess it, it's exculpatory information, potentially, that would have you decide to potentially, if it refutes what the alleged victim is saying, dismiss the case, correct?
That could very well happen, yes. Yes.
Counsel, if that's true, then your colleague's statement that some people haven't even been spoken to kind of undercuts that argument, does it not? That you haven't even spoken to all the people on his list?
If that statement is true, yes. I don't know that that statement is true. I don't know who all the prosecutor or the police or the investigator have attempted to speak to. It is my understanding that while there are 10 names listed in the alibi, somehow the prosecutor had been able to narrow it down to perhaps one specific witness, which they believe would be the key alibi witness. And I do know for a fact that that one particular witness has refused to speak to the prosecutor. To the extent that other witnesses have been attempted to be contacted or not contacted, I cannot speak to that.
Thank you.
But ultimately, I would submit that regardless of how proper the trial court's order may or may not be, regardless of how successful appellant may or may not ultimately be on appeal in challenging the trial court's order, ultimately this case came before this court because the second district chose not to consider the merits of the order and concluded that this was not a final appealable order because the defendant appellant had not satisfied his obligation of showing that he would lack a meaningful and effective remedy post-judgment. And I would submit that that is still the case today. And for that reason, unless the court has any further questions for me, I would stand on the merits of my brief on any other issues and concern and ask that this court affirm the second district's opinion below.
Thank you.
Thank you.
Mr. Communell, I believe you have used your time. You may take a minute. You'll have to turn your mic on.
I apologize. First, on some questions that were asked about materials off the record, specifically whether or not the state knew about where the witnesses were or what they'd say or whatnot. Those don't appear in the record. However, regardless of the answer, what they knew, it's alluded to in their motions to compel that they had this information. More importantly, though, the order of the trial court does not order the defendant to say where these witnesses were or when. It orders the defendant's counsel to provide written summaries of statements made to defense counsel or a defense investigator by witnesses that the defense intends to call to trial. It's much more blanket than the sort of very specific laser focus of that one issue, which may or may not have been a problem. Secondly, I think, again, in looking at Hickman, the amount of damage to literally the legal system, the way we do things adversarially, in and of itself causes harm, extrajudicial harm, well beyond the particular defendant. Anything can be appealed, anything can be rectified and appealed. But
Counsel, let me ask you this.
Yes.
You've uncovered information from witnesses you've investigated that, if true, directly refutes what the alleged victim says in this case, right?
That's correct.
Okay, so that's exculpatory information. Don't you have a reciprocal duty, just like the state would, if they found information that refutes their case or cast doubt upon their case, to get that into the hands of the state so they can assess it? And if it's correct, they can dismiss the case. Doesn't that behoove your client?
First, I don't know that there's a rule that the defense has to disclose exculpatory evidence. Secondly, of course, when the state's witnesses won't talk to them, when the defense witnesses have information that's exculpatory, of course that information is shared.
Well, you have to have a good faith belief you have to have a good faith belief that these alleged alibi witnesses are telling the truth. You can't just put them up there. You have an ethical obligation. You can't suborn perjury, right?
Absolutely. And the information that was shared with the state's own witnesses to defense counsel, along with the others, was shared as much as it could be in all relevant parts to try to settle the case.
Settle the case? Why would the case be settled? If your client's innocent, why would the case be settled?
Why would the criminal case might reach a settlement? Let's say, for example, we're talking about an adult. He said teenager. This is an 18-year-old girl. Is it conceivable that, a misdemeanor, non-affecting, non-reporting charge might have been resolved to save the money, expense, and risk of trial? Of course it would. Of course it would. So every effort was made to settle.
Mr. Communell, just to help me, you talked about the damage to the legal system, but what is it about this situation that would not afford your client a meaningful or effective remedy following an appeal? Appeal of a final judgment.
Within the statutory framework of whether or not there was a meaningful appeal, the Court of Appeals first mistakenly found that the privilege was singular. I argue that the privilege is irrelevant under Hickman, but it's certainly not singular to ask an attorney to use his collective memory, impressions of the case to try to recreate statements made. Now, the prosecution in this matter, the indictment indicates, was delayed for almost 2 years. So to go back and say, okay, the defense counsel has to segregate that which is, and this is suggested in the Court of Appeals, that which may be inculpatory, that which may have come from his client's own statements. We all know that clients say this person will tell you this, and maybe you go and you talk to the person. So that was a secondary argument that was made, that it is at best a hybrid. It's certainly not work product because it hasn't even been created, but once created, it would be a hybrid privilege.
But how does it damage your client's interest now? I mean, why is it not sufficient that you could deal with this when a trial was had and a final judgment? Why couldn't you deal with all of this on the appeal of a final judgment?
It could be, but the damage would be done. I mean, anything could be dealt with on an appeal, whether it falls within something that justifies an interlocutory appeal, such as in the New Jersey versus Tier case, or whether it doesn't, anything can be appealed. What I'm saying is that the damage here is so severe, not just the defendant. By the way, going through multiple trials is damaging to him. And it's very clear, and I agree with counsel for the state that the actual nature of the trial court's decision isn't really at issue here. But I would also say that nobody could seriously argue that it was a correct order one way or the other. It was just not. So the chances of multiple trials in the case, of potential future confinement while this is resolved, those are all real direct impacts on him.
Thank
Along
you.
with the
Thank
impact
you,
of the
counsel.
attorney.
Counsel, thank you. Thank you, gentlemen. We will take the matter under advisement. You'll be notified of our decision. Marshall, we call a recess, please.
Thank you, Justice.
The court will now adjourn for a brief recess.
2020-405 AKC Incorporated, DBA Clean Tech versus United Specialty Insurance Company et al. To the appellant, Mr. Garner.
Thank you. Madam Chief Justice, members of the court, Mr. Robinson. This case is a fairly simple one from a factual standpoint. A grease clog in a sanitary sewer line caused raw sewage to back up into the basement of the Bank nightclub to a level of about 6 feet of water, feces, urine, and other waste contaminants. At the time of the flood, the nightclub carried first-party property insurance with my client, United Specialty Insurance Company. However, the USIC policy included a water backup exclusion with anti-concurrent causation language in it, plus a pollution exclusion that collectively barred coverage for remediation of the loss. Thus, when the claim was tendered to USIC, we properly denied the claim. Subsequently, AKC became an assignee of the nightclub and brought the underlying lawsuit against my client and against a couple of neighboring restaurants that were alleged to have caused the clog. Now, when they did so, in the underlying case, USIC from the beginning relied upon the pollution exclusion, the water backup exclusion, and the anti-concurrent causation language in the policy. We did so early and often. It was in our counterclaim, it was in our motion for judgment on the pleadings, and these arguments were also in our motion for summary judgment. Ultimately, the trial court granted USIC's motion for summary judgment on all issues, and AKC then appealed. Despite the fact that it was de novo review, the Ninth Appellate District declined to even address the pollution exclusion and reversed on its belief that the water backup exclusion and the anti-concurrent causation clause were ambiguous and therefore did not apply to the loss. Now, with the support of multiple state and national amici, USIC is asking this court to reverse the Ninth Appellate District and re-enter judgment for USIC because the sewage loss is collectively barred by the water backup exclusion and the pollution exclusion. So I want to take a look at those in turn. First is the water backup exclusion. We have that cited in our brief, our merit brief, page 5. The first part of the exclusion is what I refer to as the ACC clause or the anti-concurrent causation clause. And it says, we will not pay for loss or damage caused directly or indirectly by any of the following. Such loss or damage is excluded regardless of any other cause or event that contributes concurrently or in sequence to the loss. And then it goes on to the third part. It says water that backs up or overflows from a sewer, drain, or pump. This anti-concurrent causation language, the national majority position and the rule in Ohio up to this point in time, including the Hartman versus Erie case and the Sixth Circuit's decision in Front Row Theater, says that if there's more than one cause to a particular loss, and part of that cause is excluded, such as water backing up the sewer, then all of it is excluded. And so when we look at this, in this case, there is no question based upon the evidentiary record that part of the sewage loss, if not all of it, was due to water backing up the sanitary sewer in this case. Now, why do I say that? First of all, the undisputed facts say that. When you look at our reply brief, in the merit brief that AKC filed, they challenged this issue, and then we brought up in our reply brief the specific deposition testimony dealing with water coming out of the sanitary sewer and the cleanup from that. Secondly, as we point out in our reply brief at pages 5 to 6, anyone who has any familiarity with sanitary sewers would not be surprised by the presence of water because water is an important part of the transportation of waste in the sanitary sewer systems. And we see that also in the Sixth Circuit's decision that we relied upon in our merit brief at page 16, which is Sierra Club versus Hamilton County. So the water backup exclusion by itself should have barred coverage here because water was part of the sewage that backed up the sewer in this case. Now, it was notable to me that while we were briefing this case in the fall, that your sister court in West Virginia, the West Virginia Supreme Court, decided the Motorist Mutual Insurance Company versus Zukoff case, which is cited in our reply brief at page 9, which dealt with very similar facts and virtually identical policy language and came to the conclusion that I just argued, that the water backup exclusion alone was sufficient to bar coverage under facts of this kind. Now, the argument that's made by AKC principally against this is that water only means totally pure water. That is 2 parts hydrogen, 1 part oxygen. It's a little bit like listening to Dr. Strangelove arguments about pure fluids and so forth, if you've ever seen the movie. Now, if there's anything at all suspended in the water, according to AKC, then it ceases to be water within the meaning of the USIC policy, or at the very least, according to AKC, the USIC policy is ambiguous in this regard. Now look, USIC is the drafter of this policy, and we're willing to accept any fair and reasonable interpretation of its policy, but this is not a fair and reasonable interpretation that AKC is making. To give you an example, they laid out in our briefs, dirty mop water, under AKC's argument, is no longer water. Rainwater, river water, ocean water, tap water, well water, all of which would have constituents other than just hydrogen and oxygen in it, would all cease to become water under the argument that's made by AKC here. This type of argument has been raised across the country and has been roundly rejected when it has been raised. And we've cited these cases for you in our brief at pages 12 to 13. The Newberg case from Minnesota, the Penn America case from California, the Sotrano case from Massachusetts, to name a few. We would suggest to this court that this court likewise should reject this type of an approach, pure water argument, and find that that is not a reasonable interpretation of this policy. Likewise, we would submit to the court that AKC's reliance upon the Fairlawn Properties case, the 1982 Ninth Appellate District case, is also misplaced. We've addressed this in our brief at pages 11 to 12 of our merit brief. First of all, the Fairlawn Properties case does not address an anti-concurrent causation clause. There's nothing in there about it. We know that from the Hartman decision in the Front Row Theater and the assumption that this court would follow the national majority position, that makes a difference. Secondly, importantly in that case, based upon the record that was presented in the Fairlawn decision on page 3, the court specifically found there was no evidence of any backup of water to the sanitary sewer in the Fairlawn case. And so under those circumstances, the record is simply different factually. Thirdly, and I found this one to be surprising when I was preparing for oral argument in this case, because it went to some of the underlying themes of why we're here before this case. The Ninth Appellate District also apparently declined to exercise de novo review on motion for summary judgment in this case 40 years ago. They specifically said at page 3, we find the trial court's judgment as to the exclusion being ambiguous is supported by the record. Trial court's judgment carries a presumption of regularity, and we cannot substitute our judgment for that of the trial court. That's just simply an incorrect statement of Ohio law. On a question of law, the appellate court gives no deference on a de novo review to the trial court. It can make the decision that it wants. So again, we saw a wrong standard being there. And then finally, the Fairlawn Properties case, there was no explanation or analysis of any other exclusions, unlike the connection to the pollution exclusion that we have in this case. So therefore, it's a dissimilar case. This leads us directly to the pollution exclusion in this case. And again, we have the pertinent parts of that exclusion set forth at page 6 of our merit brief. And at page 6, what we have is this language. We will not pay for loss or damage caused by or resulting from any of the following: discharge, dispersal, seepage, migration, release, or escape of pollutants. And then there's a couple of exceptions which are not applicable in this case and have not been argued by any party in this case.
John?
Yes.
So you essentially, this is an ISO form that you could modify, that your client's company could modify. So you've got pollutants, which the court ruled out, and you have water. Now, from what I see, it looks like some insurers have taken that ISO form and said water and sewage. Is that a good argument against what you're telling us, or is there an explanation that could help?
Yeah, there's absolutely some insurers that have done that, and they've taken it out. In fact, one of the cases in Ohio that addressed that was the Hartman case, where they said sewage and water. But I don't think it makes a difference, Justice Bruner, in light of what we're talking about here. And part of the reason why is because of the arguments that were made with respect to the water backup exclusion in that particular case. We start getting into those issues of, okay, how pure does the water have to be until it's just considered to be water? I think a belt and suspenders approach, certainly you could say sewage, but the prevailing rule in the country has been that if you have constituents suspended in the water, then that's water too. And that's just sort of a plain understanding, reasonable understanding of what water is. Sort of going back to my examples of the mop water and the river water and other things that always have something else suspended in it. So is there something else that could have been added? Sure, they could say sewage, they could say if it has sticks in it, if it has leaves in it, if it has other things in it, but we don't. I would suggest to the court that we don't want to get into a place where we have to list everything.
Sure, but and I'm sorry to cut you off there, but I want to keep to our time. But the company also argued that sewage fit under pollutants as well, correct?
Yes, we did in this case, correct, from the beginning.
So does that create an ambiguity?
I don't think so. I think it's an overlap where you have, if anything, you have a redundancy, not an ambiguity. Because what you have is you have two different things that are there. I mean, it's conceivable that you could have a pollution situation that doesn't involve water backing up a drain, right? And so under those circumstances, and remember, we're talking about a first-party policy here. So we're not talking about something that where there's coverage being provided to AKC, or in this case, the nightclub, because they polluted somebody else's property, which is where we typically see this. In this situation, we're saying if their property is damaged because of pollution, then there's no coverage for that, unless one of these exceptions exist, which are not involved in this case and have never been argued. So both of those together come together to say that's the reason why we're so strong in this case in terms of what the coverage position is. I think it's also the reason why we attracted the amicus support that we did in this case, because there really should be no conceivable basis for there to be coverage under the facts of this case.
Because
when you look at this,
I think what you're getting to is that conceivably, because it came from an outside force, that there's most likely other insurance that would actually cover the loss. Isn't that kind of the rationale behind it?
that may be, and in fact, there were lawsuits against Brickell and Cilantro here, but AKC lost those lawsuits. They weren't able to establish liability. So even if there was liability coverage that would come from an outside, it wouldn't be triggered because this court in Goodyear, paragraphs 21 to 22, which are cited at page 17 of our brief, explain that all that means is you simply have to have a movement of the pollutants from one place to another. We certainly had that in this case with raw sewage moving from the municipal sanitary sewer system and entering the basement of the nightclub. Thus, the plain language of both the pollution exclusion and the water backup exclusion should have barred coverage here. Either one of them separately probably could have. The Anderson versus Highland case shouldn't result in anything different here. Number one, because this is a traditional environmental claim, whatever that means. Number two, if we're going to get into this issue of what a traditional environmental claim means, we've urged this court to simply limit Anderson to its facts because it's really difficult to understand exactly what was meant by that. So in conclusion, what I would say is that both exclusions working together bar coverage here. As you've mentioned, Justice Bruner, there are other ways that there could have been coverage here. In fact, the USIC policy itself, as we point out in our reply brief at pages 10 to 11, could have been endorsed to eliminate the water backup exclusion and to eliminate the pollution exclusion. But neither one of those things were chosen by the insured in this case. And our amici have also pointed out that there are other types of coverage, including environmental coverage, that could have been purchased here if the insured thought that it was worth the money to spend. But none of that happened. And there's no coverage under this policy. And therefore, we're asking that the trial court's decision be reinstated, the Ninth Appellate District be reversed. And Chief Justice O'Connor, I apologize. I did not ask to reserve time, but can I reserve my remaining minute 20?
Yes, you may.
Thank you, Your Honor.
Mr. Robinson.
Chief Justice O'Connor, and may it please the court. I think it's clear that United and its interest group, amici, want to turn this case, or rather want the court to turn this case into a referendum, both on Anderson and on the well-established principle that ambiguities in a form insurance contract are construed against the drafter. Here, in this case, construed against the insurer. But I think in reality, the case doesn't lend itself to either of those purposes. The case doesn't exist in some kind of legal vacuum. In reality, it's extremely fact-bound, and it's also, somewhat uniquely bound to the kind of vexing procedural history that the case has gone through. So ultimately here, the issue isn't one of overarching legal theory. It's one of case-specific practicalities. And in that regard, we have to remember that this is a summary judgment case. So the real overarching issue is whether there is anything in this specific factual record that constitutes noteworthy evidence that a dispute regarding a genuine issue of material fact exists. So what does that look like here? I think one question is it the case that there is no evidence that the sewage that backed up here consisted of a liquidy solid muck rather than water?
Well,
is there?
Isn't sewage doesn't sewage by definition include water? I mean, I look up the definition of sewage, and what I see is water that backs up or over. Well, the policy says water that backs up or flows from a sewer drain or sump, and sewage is defined to include, to be waste suspended in water.
Sure, we would readily concede that sewage typically includes water as a component element. I think the issue here is definitional. You know, we're not looking into.
What are you saying, that there's no water in this sewage? I don't understand.
Sure.
What's the factual dispute? I mean,
if you were drinking a glass of Coca-Cola, would you say I'm drinking a glass of water? So the issue there would be not, is it a constituent ingredient of the substance, but is that substance in the normal everyday use of that language, water? If someone said, I had water back up.
Don't you think that if someone who spoke the English language read a phrase that said that there's no coverage for, quote, water that backs up or overflows from a sewer, drain, or sump, and sewage came from the drain or sewer, don't you think someone would think that's covered by the policy? I'm a little lost on that.
I think it would be covered by the policy, yes, but it wouldn't be covered by the exclusion. I think that if someone tells you that water backed up in my basement, it's a whole different animal than sewage backed up in my basement.
So because there's something else in the water besides pure water, that's the problem?
No, because it's a different substance. So if we look at the text of that exclusion, look at the next one down. The water exclusion applies to water that backs up or overflows from a sewer, drain, or sump. It also applies to a mudslide or a mud flow. Now, what is mud composed of? It's composed of dirt and water, right? So why is there a separate line for mud, for a mudslide or mud flow, if anything that has water in it as a constituent component is water? And I think the answer is that in everyday normal course of language, just because a substance contains water doesn't make that substance water. Now, the appellant argues that we are trying to suggest that the water has to be pure, there can't be any other substance present in any way. That's not the test. The test is where, on normal usage, the substance would be referred to as water, or it would be referred to as something else, whether it would be referred to as a mudslide, as Coca-Cola, as sewage.
Counsel, there's two sewer systems, right? There's a sanitary sewer, which is, your sewage, and then there's the, like for rainwater, and if the systems are set up correctly, they don't intermingle. Is that correct?
That's absolutely right.
All right.
Chief Justice.
Okay. And so what you're saying is that the coverage extended was only, it would only exclude pure rainwater from backing up from coverage if it backed up.
That's correct with a caveat. We would say that it excludes coverage for storm sewage backup. So it doesn't have to be pure rainwater. Any kind of water that comes from a storm sewage that a normal person in everyday usage would say that was water in my basement.
Okay, all right, wait a minute. Storm sewage, define what you're talking about.
It's what you're talking about, Your Honor, the distinction between sanitary sewage and storm sewage. So
do they use that term, storm sewage, for water that backs up from rainwater?
Yes. Yes, Your Honor. A storm sewer system is a system that contains only rainwater and other surface water runoff that doesn't have sanitary sewage in it. And I think that's why this provision says from a sewer, drain, or sump. You know, that phrase, a sump under the Ohio Administrative Code cannot contain sanitary sewage. It has to be storm sewage. And
okay, but it says a sewer. It doesn't distinguish between a rain, surface water sewer and a sanitary sewer, does it?
No, the provision does not. No, and we don't.
So why wouldn't it be read any sewer? If water backs up, anything backs up from a sewer. I mean, the only thing that really goes in a sewer is water with either, even if it's rainwater, it's going to have something suspended in it.
That's right. That's right.
Okay. So why would it, anything from the sewer, why would it have to say excluding or I guess, why wouldn't you think sewer meant sanitary sewer?
Oh, I think it can mean sanitary sewer in for instance, a city that has a combined sewer system. If a heavy rains cause a backup of stormwater through a sanitary sewer system, a combined sewer system, that would be covered. But when the substance is described as it is here, and again, I would urge the court to look at the factual record. When the cleanup witness was asked, was this water? He said it was a liquidy solid. He refuted the idea that it was water. I would urge the court to look at the reply brief where the questioning attorney presses it as water, but the witnesses did not concede the point. There's a couple other very important issues on the water exclusion as well. One is the cases that my opponent cites, the two cases. The one is the 6th District decision in Hartman, and the other is the 6th Circuit decision in Front Row Theater. Both of those make my point. Both of those involved storm sewage, water runoff only. There was no involvement of sanitary sewage. The other critical issue, I think absolutely critical issue on the water backup exclusion is that the issue was not raised in summary judgment. It was not raised in the opening brief or in the reply brief of United, and it was not raised in the appellate brief of United. It was listed in the appellate brief in a footnote that name-checked a number of provisions that could apply in the alternative, but it's black letter law, as this court is well aware, that simply naming a provision does not preserve the issue. Rather, it has to be properly briefed and argued, and it absolutely was not briefed or argued in this case. The same goes with the anti-concurrent causation clause, the ACC clause. It was neither briefed or argued or even name-checked below. So for United to bring those issues up now, it's just should be impermissible. The only thing they can hang their hat on at this point, we believe, is the pollution exclusion. I would point out before I transition to the pollution exclusion, one last thing on the water exclusion. And that is the point that Justice Brunner raised earlier, that State Farm, that Erie, that Motorist Mutual, that a countless number of insurers have written this provision to say that water or sewage that backs up or overflows not covered. The simple solution here, the appellant has had 40 years since Fairlawn, 20 years since this court decision in Anderson, is to do what all of these other major insurers have done and do a simple two-word edit at or sewage. That would eliminate years of litigation, years of ambiguity that favors the insurer when they're trying to market the policy, but then disfavors the insured when it actually comes time to collect on a claim.
But counsel, is it true that there's separate policies that direct that are protection for sewage backup?
There certainly are those policies. To my knowledge, there's no evidence in the record here that United offered one. There's an argument, I believe, in the appellate brief, but there's nothing evidentiary in the summary.
Okay, but you don't deny that that coverage exists, and your client or any other business or private citizen could purchase it to protect their property.
Yes, just about coverage for just about any kind of casualty exists somewhere in the market. All right, moving on then to the pollution exclusion. I think that it's fairly clear that reliance on that exclusion is precluded by Anderson, but even if we set that aside, there are several reasons why that doesn't apply here. One is the thorny procedural posture of the case. As the court is already aware, I'm sure, the Court of Appeals held that the issue was moot. That's primarily due to the kind of the puzzling nature of the trial court's opinion, but nevertheless, the Court of Appeals held that. United asked this court to take up the mootness issue, and the court declined. Therefore, we would submit that the pollution issue is not properly before the court because of that mootness reason, just as the water exclusion is not before the court because it was not argued or briefed in either court below. But if you were to reach the merits of the pollution exclusion, we think it's very significant, and the trial court found this. The verb backs up, which perfectly describes, we would readily concede here, what the sewage did, the action that the sewage undertook, is not included in the list of pollution exclusions, in contrast to the water exclusion. We think that it's a well-established principle that use of language in one provision and not in another means that the drafter intended a different use in both locations. I should address briefly, since it came to mind, counsel's assertion that the Goodyear case states that any sort of movement satisfies the dispersal, etc. provision of the pollution exclusion clause. That isn't true. If the court reviews its decision in Goodyear, the waste at issue was moved from Goodyear's facilities to a landfill. The court said that that movement did not qualify as a dispersal or the other verbs that are listed in the sequence there in the pollution exclusion. So while the court did, this court did characterize those verbs as generally describing movement, it did not hold that all movement satisfies the provision. To the contrary, the movement in that case did not satisfy. To wrap up the whole thing, I guess we need to go back to the fact that for 75 years, this court has held that insurance contracts and ambiguities insurance contracts are construed against the drafter, and particularly in the context of an exclusion. That rule has special force.
Counsel, before you stop, would you address the West Virginia Supreme Court case that Mr. Garner referenced and its relevance?
Sure. We certainly wouldn't deny that courts in other jurisdictions have on occasion gone the other way. And in that particular case in West Virginia, they did hold the other way, but I would note that in so doing, they relied on their own precedent and from a case that had a water backup exclusion that explicitly said water or sewage backup. Now they didn't, this particular policy that was at issue in that case didn't include that language, but they relied on the previous case.
So the language
into this one.
The language in the West Virginia and this case are the same. They don't include sewage.
That's correct. That's correct. As to the water backup exclusion, that's correct. All right. Wrapping up then, I think that it has been the law of Ohio since whenever the case was, the issue was addressed, at least starting with Fairlawn in 1982, that a sewage backup is not a water backup. Opposing counsel is unable to cite to a single case in Ohio that has ever held that a water backup from a sewage system, I beg your pardon, that a sewage backup from a sewage system constitutes water. Not a single case. Neither Hartman or Front Row Theater gets that job done for counsel. Likewise, no Ohio court has ever held that an insurance pollution exclusion applies to sewage. So we have decades, we have what counsel in their briefs admit has been years of litigation, never a single holding. The simple solution is to add a two-word phrase for sewage. Thank you.
Thank you. Mr. Gardner.
Thank you. First of all, starting with whether or not the issues were preserved, I just would direct the court to pages 12 to 16 of our reply brief. It is essentially a reiteration of what we put in our memo contra the argument that the case be dismissed as improvidently allowed. As I pointed out, I raised the issues. We raised the issues early and often and thoroughly. I understand Mr. Robinson came in the middle of briefing here, and he may not be as familiar with the underlying record as we are, but we give you the pinpoint citations so you have them if there's any question at all. Secondly, one of the things Mr. Robinson indicated was that there was no reference to water. I would indicate there are no genuine issues of material fact here, that there may be disagreements as to the implications of those facts, but not as to the facts themselves. And again, if you look at pages 4 and 5 of our reply brief, we have 4 specific examples cited of the water there. Konerman's deposition where he testifies, I'm assuming you didn't walk down into the water. Answer, no. Konerman contacting the city of Akron for a work order on the sewage loss. The nightclub is holding water and sewage. The depth of the water / sewage was 4 to 5 feet, and then describing what takes place. Mr. Bradshaw's deposition testimony, the dehumidifier saw any water damage, especially in a large loss such as this one. When I say water, he goes on talking about the water. And then finally, the fourth thing being on the nightclub when authorizing the remediation indicated that it was to remediate damage caused by water / sewer. There's no question water was involved.
Although
your briefing asserts that either exclusion defeats coverage. It seems to me you kind of actually need elements of both exclusions in order to get the result that you want here.
I think the belt and suspenders approach is the best way, Justice Stewart. I agree with you. I think that under the circumstances here, I would not argue one or the other. That's why we argued both. I think that the national majority position is that, again, going back to cases like the Newberg case, that when we start getting down into how pure does the water have to be, that's sort of a self-defeating place. So I think we could have won just on the water backup exclusion, but that's not the hand we're playing, and that's not the hand we're asking you to decide, Justice Stewart. We're asking you to decide the two exclusions in tandem together.
But isn't the fact that there are decisions on both sides of the issue of whether a water damage exclusion includes sewage backup undermine the argument that this case is proper for summary judgment disposition?
I think there are very wise jurists throughout the country that ask that question all the time. And as somebody who represents people relying upon standard contracts, if the rule is going to be, if one judge somewhere finds that there's a different way to look at this, that there's necessarily an ambiguity, then I think we're all in trouble.
We're not talking about one judge, though. We're talking about several decisions.
There are several decisions, I agree. But I think the overwhelming national majority view is that the water backup exclusion alone would bar coverage, that the pollution exclusion would bar coverage. And I think combined, that should resolve some of the issues here. Because if you think about it, Justice Stewart, when we look at the Fairline case, the main reason why they found there to be an ambiguity is because there wasn't a pollution exclusion in that case. And so they said, well, it could be sewage, it could be pollution, it's not just all water, and they didn't deal with an anti-concurrent causation. So when we put all that stuff together, I think we get around any kind of problem in this case as to whether or not there should be a different result reached than what the trial court reached, which was judgment for USIC.
And the trial court based it on the pollution exclusion.
I would agree. That, yeah, they did. And
to be correct. You seem to use the water exclusion.
Well, it's interesting because she styled it, Judge Jones styled it as being under the pollution exclusion, but it's clear when you look at her decision that she's also referring to the water backup exclusion. So when Mr. Robinson was referring to it as sort of thorny, I think that's what he was referring to, is there was some blending of some concepts, because if you look at our appendix, page 21, she starts off with, under the policy, loss or damage resulting from water that backs up or overflows from a sewer drain or sump is specifically excluded from coverage, and then goes on and blends the two exclusions together under the title of the pollution exclusion. That may have led to some of the confusion in the Ninth Appellate District. But again, it's pretty clear that we argued both and we presented both, we preserved both, and we should have been able to argue both at the Ninth Appellate District. Their pollution exclusion was never moved in this case under any set of circumstances. Thank you.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Our last case this morning is 2020-658, 2020-991, the State of Ohio versus Marshall Williams. For the appellate, Mr. McCaleb.
Good morning, Your Honors. Chief Justice, may it please the court. My name is Robert McCaleb, and I represent the appellant, Mr. Marshall Williams, on behalf of the Cuyahoga County Public Defender's Office. With the court's permission, I'd like to reserve 5 minutes of my time for rebuttal. There is no reason to expect an ordinary criminal defendant to know on his own that it is very dangerous and potentially unethical for one attorney to represent two people in the same criminal case. I imagine that many lawyers didn't even learn this until law school, or perhaps even after, and yet the practice continues to occur with some frequency. However, this case offers a simple and clear means of ensuring that everyone is aware of the rights and risks that are involved, and of doing what you have already said trial courts must do. So we know that a possible conflict of interest is, quote, inherent in almost all instances of joint or multiple representation. This court said that in State versus Dillon. And we also know that a trial court already is required to inquire whenever it knows or reasonably should know that a conflict of interest exists, or a potential conflict of interest exists, I should say. So what this case would do is essentially close the circle that was started in Gillard and Dillon, and other cases, both from this court and from the United States Supreme Court, by explicitly requiring judicial inquiry whenever dual representation of co-defendants in the same criminal case is occurring. Now,
Counsel,
this
counsel,
should be done.
Counsel, at trial, or excuse me, in the trial court, there was never a request for that kind of instruction, right? The defense counsel represented both of them, husband and wife, right?
That's correct.
Okay, and all along there was a joint plea deal that was pursued, correct?
That is also correct.
Okay, and my understanding is the way it turned out is that the husband did time or was sentenced, and the wife avoided jail and was put on probation. Is that correct?
That is also correct. Yes, Your Honor.
Okay. So I guess I'm trying to figure out how the judge would have viewed this as, you know, they're negotiating a package. Nobody is pointing fingers at each other. How would the judge have viewed that or known to view that as a conflict?
Well, so I think that the fact that it's a package is actually part of the problem. A possible conflict of interest, first of all, that's all that is needed to initiate the inquiry, is a possible conflict of interest. And so a possible conflict of interest can occur anytime that the defendant's interests might diverge. And so just the mere fact that they were being represented by the same attorney, I think right there you have a possible conflict of interest. But then the package plea deal.
Counsel, what's the factual basis against the wife in the first place in this case?
Well, so I was not her counsel at trial, nor on appeal, but I will say it was the marital home that was searched and where drugs were allegedly found. So Mr. Williams, my client.
What we're looking at as maybe a good deal for her may not have been. If she had her own zealous attorney representing her, she may have had the charges dismissed. Is that correct? Altogether?
That is correct. That is correct as to her, and I think it's also potentially correct as to Mr. Williams. And so, you know, I mean, this from some perspectives might look like a good deal for one or both defendants if you just assume that they're guilty. But, you know, given the problems in this case, I'm not sure that that's a safe assumption to make. And so one of those problems is this joint plea deal, where the trial court is not only.
But Mr. McKay, let me interrupt you but I do understand what you're saying, and there is the potential here for unequal representation or conflict. But the trial court judge has a lot going on. And if neither party, and we do have cases where both the defendant has raised a possible conflict and the state has raised it, if no one raises it, if no one complains about it, and if there is nothing that indicates to the trial court judge that there may be a problem with a conflict, what authority is there for I think what you want us to do, which is to say, anytime one lawyer represents co-defendants, the trial court should automatically inquire about a potential conflict?
Yeah, and that is exactly what I'm saying, Your Honor. And I think the reason is that, so first of all, I think that if the trial court is waiting to initiate an inquiry until it knows that there is an actual conflict,
Or
well, at
just,
that point,
or if someone brings to the court's attention that there could be anything about it. Doesn't even have to say it has to exist, but anybody raises the iota that there might be a conflict.
Mr. Caleb?
it's certainly helpful if someone raises that. I mean, that makes it, essentially unmistakable at that point. That kind of puts it in a, it's whether the trial court knows or should know. And so if someone raises it, that kind of puts it into the no category.
Mr.
But
Caleb,
we know, yes.
Can that kind of conflict ever be waived by a client?
I think it depends. I think it is ultimately, it depends on the facts of the particular conflict. I think that there are certainly situations where it could be waived, but I think that raises the important point that it should be waived, affirmatively waived, because of what's being risked here, the different treatment. And this sort of thing can sort of sneak up on you. It's not always, extremely obvious that this defendant wants to testify against that one and the other vice versa. Sometimes the conflict sort of matures and materializes and becomes more serious over time. And so, I think it depends on the facts of the case. Some conflicts can be waived, some, depending on what's happening, probably can't. And ultimately, the rules of professional conduct kind of serve as a backstop here. But I think what this case is kind of standing for is that there would be a sort of two-step process where the trial court is first engaging in this inquiry to make sure that the co-defendants are aware that they have the right to independent counsel, just as the trial court has to make sure that the defendants are aware that they have the right to counsel at all. And then
Mr. McCaleb, but some of the issues that arise are that the counsel may be refraining from zealous advocacy, or I don't even need to use the word zealous, for one, because of how it might overshadow some kind of defense of the other. So is that kind of conflict really waivable by a client?
Can
you find that it is?
I would be very skeptical that that would be kind of, I think, one of the ones that's more sort of obvious or just apparent on its face from the nature of the conflict is probably difficult to waive. But that's exactly the sort of thing that is risked by this sort of situation. And the trial court might not necessarily know exactly what the conflict or even the possible conflict is beyond the fact that it is inherent in almost all instances of joint or multiple representation, but it will at least know that that is true, that is just sort of true, particularly if this court holds that it is true as a legal matter. And so I don't think that it would be an adequate solution to require a defendant himself to object. First of all, it isn't required because we know that a trial court can be obligated to make the inquiry because it merely should know. And so presumably if it should know, no one has objected. And so we see United States Supreme Court cases like Sullivan where that happens and where that rule is first established. And then even in this court's decision in State versus Dillon, that's kind of that case involves an objection and the nature of how that objection should be levied. But this is really more of a no should know case. That's just because the trial court presumably knows, and at the very least should know, that the parties appearing before it are being represented by the same attorney, then that raises that duty merely to inquire. The government, in its brief, and I anticipate it'll argue today, says that, first of all, there's no problem here. There wasn't a problem that the court could or should have seen. But even if there was a problem, the appropriate remedy is remanding to have that hearing, to have the inquiry into the possible conflict of interest. So I agree with the government, and I disagree with the government. I agree that an appropriate remedy would be to hold a hearing or to conduct the inquiry on remand. And that's exactly what this court directed to occur in Gillard, specifically in Gillard 2, and then kind of reaffirmed that in Gillard 3. But
Mr. McCaleb, let's say we agreed with you and we remanded and told the trial court that it had to conduct the inquiry. What happens if the trial court says, you know, we should have had two counsel, not just one? What does the trial court have the authority or the jurisdiction to do at that point once there's been a final sentence imposed in the case?
Well, so I think at that point, the appropriate remedy, if the trial court determines that there was a conflict of interest or that there should have been separate counsel, the appropriate remedy would probably be to vacate the plea at that point, and then essentially, you know, restart the case. That part, you know, this sort of complication, I think, is why the easier or the quicker this is done in future cases, the more smoothly it will go.
Well, can the trial court vacate the plea without somebody having to file a motion to withdraw the guilty plea then?
Well, I think so. I'm not, I mean, this is a, you know, so sort of relatively, you know, new field of litigation. I think probably what would happen, and I guess I'm not certain that this is how it would unfold, is that we would have the hearing. I assume my office would represent Mr. Williams. If there was a determination that there was an actual conflict of interest, then we would then move to vacate the plea as having not been knowingly or intelligently made, because it was made with the assistance of actually conflicted counsel. But at this point, I mean, we just don't know. There's a lot to be suspicious about in this case, to be sure. But at this stage, the government questions the fact that Mr. Williams hasn't shown prejudice. And although I think that there could certainly be made a showing of prejudice here, and it's certainly easy to imagine what the prejudice would be.
Doesn't the prejudice go to a fundamental right?
Well, so here the prejudice would only need to be shown if we were actually at this stage saying that there was an actual conflict of interest and that it did prejudice the defense. At this point, the prejudice is essentially that there was a possible conflict of interest and an inquiry wasn't had. And that has been the sort of level of inquiry that this court has engaged in previous cases and that the Supreme Court has engaged in, going all the way back to Holloway in like the 1970s.
But my question is,
where the court said, "We'll say."
Doesn't that go to a fundamental right? I mean, if you find there's prejudice, what's the prejudice?
So I think here, yeah, if you find that or if the trial court finds that Mr. Williams was prejudiced, I mean, it implicates like almost all of the rights that a criminal defendant has potentially. That's certainly the right to counsel, certainly the right to due process, things that this court and the Supreme Court of the United States have both referred to as the most fundamental Fifth and Sixth Amendment rights, that assistance of counsel aspect. But you can imagine that
Counsel, you're requesting then that we not make a determination on whether there was a conflict or not. We send it back to the trial court to determine that, the same court that heard it.
Yes.
Okay, counsel, all right, that's yes or no. And then what do you do with the Manross standard, I guess? The court had a duty to investigate the potential conflict, and if there was no duty, the appellate court must determine whether an actual conflict occurred that adversely affected the ability. So are you saying just by looking at the fact they're husband and wife and they're charged, that's a conflict?
So not that they're just husband and wife, but that they are co-defendants, and that they're co-defendants, that alone I think is sufficient to create a possible conflict of interest. But in this case, it's that they're engaged in a package plea deal, that they are being represented in this case by an attorney who has since resigned his license in the face of a veritable mountain of ethics complaints and some findings, and that was likely known to the trial court, since that was all it was big news in Cuyahoga County. And so all of that is sort of happening at once in this case. So it goes even beyond just the language in Manross or in Dillon. into this territory where there are a heap of problems. And I think that's sufficient, certainly sufficient altogether to create this, to make the trial court know that there was a possible conflict of interest. And because the trial court knew, or at least should have known that, and didn't have a hearing, we would request, and I think on this we agree with the government, that there be a remand for a hearing on the question of whether a possible conflict of interest.
Okay, thank you. Mr. Zelnikar?
Chief Justice O'Connor, may it please the court. My name is Frank Zelnikar. I'm an assistant prosecuting attorney for Cuyahoga County, and I'll be representing the state of Ohio in this matter. Your Honors, the sole question before this court is whether a trial court is always required to inquire of co-defendants when they are represented by the same counsel, even if neither defendant objects to the joint representation at the time of trial. This court in State versus Manross has already answered that question in the negative. The United States Supreme Court and this court have both recognized that multiple representation does not violate a defendant's right to effective assistance of counsel unless it gives rise to a conflict of interest.
Mr. Trial court, let me ask you, what would be the harm in the trial court inquiry? It would be a matter of seconds. It could ward off potential problems down the road. It gives criminal defendants, make sure that they understand that they do have the right to separate counsel, or if there's been a discussion about potential conflicts. What's the problem with that? Why isn't that a good practice?
Well, I think in State versus Manross and in Kyler versus Sullivan, both those courts have stated that that probably would be best practice. But the question isn't whether or not it's best practice. It's whether or not it is constitutionally required. And at the appellate level, where the defendant at the time of trial didn't object to this, there was no indication of a particular conflict. Should we be remanding it when the...
Why can't there be a constitutional requirement? Why isn't it a constitutional requirement that a criminal defendant understand what sort of representation he or she is entitled to?
Well, the constitutional requirement as it stands, as decided in Kyler versus Sullivan and in State versus Manross and State versus Gillard, is the fact that it's whether or not you're entitled to effective assistance of counsel. And effective assistance of counsel means assistance of counsel that is not marred by a conflict of interest. And in this case, you first have to show that there was an actual conflict of interest. Now, whether or not there's a constitutional mandate, this court has decided that, but if this court wanted to, it clearly has the ability to read that into the Ohio Constitution, as the Ohio Constitution is a document of independent force. But in all of the jurisdictions that the defense counsel cited to in his brief, every one of these jurisdictions, the federal courts, the Kentucky, West Virginia, all of those have adopted this rule that he's proposing, this mandate that the courts make this inquiry when it sees joint representation. It has done it by rule, by criminal rule. For example, if you look at Kyler versus Sullivan, which is probably the lead case, the United States Supreme Court case in this area.
Is it the position that, so are you saying the state really isn't opposed to this? The state is just opposed to it being found or being required under the Constitution?
Well, I'm opposed to it being found as a constitutional mandate, as I haven't seen any states, and I could be wrong, there could be some out there that have found this as a constitutional mandate. And the Supreme Court, this court has generally mirrored.
So are you opposed to it on principle?
I'm not opposed to a criminal rule that addresses the issue of what a trial court's responsibility is concerning joint representation. No, I mean, clearly the trial courts could benefit from a rule in the criminal rules to tell them what to do when they're in this situation,
well,
whether or not it should be.
Counsel, the 8 districts language, and I find this a little disturbing. The attorney representing multiple defendants is in the best position to determine whether a conflict of interest exists or might develop. And then that is the reasonable for then, and that is reasonable for a trial court to assume that there's no conflict and the defendant normally accepts the risk of conflict or that. Okay, so if we're leaving it up, by that to the attorney who's actually maybe being hired, receiving a higher fee, possibly influenced by the welfare of one defendant over another for various reasons. So when you're saying you want to leave that up to the attorney to make that call, is that really what we want?
Well, I mean, I think the 8th District in that case, in their opinion, was parroting the decisions in, I think, Kyler versus Sullivan and the Ohio Supreme Court. I believe the Ohio Supreme Court said the same thing in Manross, where the attorney is in the best position to determine.
Yeah, I know they're saying that. I'm saying, we have this before us. This is our opportunity to take a look at that statement and say, is that really true? Is that something we want to, be bound by?
No, and I agree with you. And I don't think they are they are obviously in the best position out of all the parties involved. The attorney and their clients are in the best position to determine whether or not there's a conflict, whether or not they're willing to accept it. However, this court, it doesn't mean the trial court doesn't have.
Counsel, can't you fathom a time where there's co-defendants and one is totally oblivious to the fact that there's a conflict here?
Yeah, yes, Your Honor. And this is why, again, what I was going to say was the trial court, it doesn't mean the trial court it's solely left up to the trial court. Like, again, in Kyler versus Sullivan and in Manross and in Gillard, the trial court's duty to inquire is when the trial court knows or reasonably should know that a conflict exists.
Let me touch on that, Counsel.
So, Counsel, what about the prosecutor's role here? I mean, obviously, the prosecutor's, seasoned enough to realize that there may very well be a conflict, and they know what's happening. They know they can see it. What's the duty of the prosecutor?
Generally, it's from my understanding, and usually the practice in my office is obviously when we see conflicts or something that looks like a particular conflict, we will bring it up to the trial court to make the trial court aware of it, because clearly we don't want a conflict to arise later down the road. So if we notice a conflict, we'll bring it to the attention of the trial court.
Well, Counsel, let me ask you this. Isn't the conflict obvious in a criminal case when a defendant is representing two people with various different theories of guilt on each one of them? Doesn't that give the prosecutor the opportunity in your plea negotiations to use one defendant as leverage over the others? I will give you this, but the other defendant has to plead to this.
Well, this is exactly sort of the same argument that the defendants in State versus Manross made. In State versus Manross, we had a situation very similar to the case here. In State versus Manross, you had a mother and a son where the son was selling drugs out of their home. The son was charged with 9 counts of trafficking and things of that nature. And the defendant, the other defendant, the mother, was charged with just 1 count. And they had different, obviously, theories of liability and things like that. And on appeal to this court, after they got convicted after a trial, on appeal to this court, they made that exact same argument. And reading from this, the court's decision, the court specifically stated when they made that argument that the differing degrees of proof against the co-defendants are in and of themselves insufficient to establish an actual conflict of interest. At best, they're a basis for speculation. Now,
Mr. Zalesky,
no one's
at some point, do you agree that there are some conflicts involved with joint representation that cannot be waived by the clients?
Yeah, of course. There are some conflicts where they have just completely differing degrees of defense. For example, and I think one of the justices brought it up, is when someone is literally pointing the finger at their co-defendant. In that situation, I don't see how you can waive that, and I don't see why anyone would want to waive that sort of situation. But in this case, we don't have that at all. And I don't think the defense.
So if we were to draft a rule, how do we tell attorneys and courts when it can go forward and when it can't? I mean, how do we differentiate that? Aren't there a myriad of different situations that we would have to anticipate?
Well, sure. And I think there are multiple criminal rules throughout the country that we could take guidance from, criminal rules that do require trial courts to promptly inquire. And I think the most telling part of all these rules, and particularly in the jurisdictions that Mr. McCaleb cites in his briefs, is that even in situations where the trial court by rule is required to make this inquiry, and where the trial court fails to make the inquiry, and where the defendant failed to object at the time of trial, on appeal, that in and of itself is not going to be enough to mandate a reversal. On appeal, in all those jurisdictions, you still have to show some sort of actual conflict. And I believe in West Virginia, you have to show a likelihood of an actual conflict. So you still have to demonstrate on appeal that an actual conflict existed. And if you demonstrate that an actual conflict existed, or there could be an actual conflict, well, that's when we look at State versus Gillard. And in those situations where the trial court was required to make that inquiry, and there's evidence of an actual conflict, the remedy is to remand it back to the trial court to have an after-the-fact hearing to determine whether or not there was an actual conflict.
Well,
However,
is a wide variety of, 9 years opposed to community control, is that any evidence of a conflict?
Well, no, I don't think so, because the state, if you look at the plea agreement, the state never argued for a specific, nor was there a specific time as part of the plea agreement. The state at sentencing just stated, we'd like, to sentence the defendant to prison, because under the count one that the Mr. Williams pleaded guilty to, it was amended from a mandatory 11-year sentence to the possibility of any time, mandatory time between 3 and 11 years. The state at sentencing didn't argue for a specific sentence that was given by the trial court. And I don't think the defendant's sentence was also made part of the plea. So when it came to the court sentencing, that was just the court sentencing. I don't see how a conflict, I think in his brief, Mr. McCaleb makes an argument that they could have argued differently. That's purely speculative, but I don't think that the sentencing or the sentences that they both received are any indication of a conflict. Generally, to show a conflict, you have to show that there was a defense that one of the defendants couldn't use because it would require the defense attorney to violate the loyalty he has or the duty to the other co-defendant. And we haven't had that presented here. And in situations where the defendant does show that there was an actual conflict of interest, the defendant still has remedies. The defendant can still file, for example, if the defendant has evidence outside the record, they can file a petition for post-conviction relief, claiming that their Sixth Amendment rights and their Ohio and their rights under the Ohio Constitution were violated based on ineffective assistance of counsel due to a conflict. That could be raised in a petition for post-conviction relief. Or if it's obvious from the record, they could raise it on direct appeal. But in this case, we haven't had any indication of an actual conflict. And if you look at State versus Manross case, it makes it clear mere speculation is not going to be enough to raise to that level of an actual conflict. And again, if this court wants to draft a rule, the proper avenue, and I think I make this pretty clear in my brief, is to just go the route of all the other jurisdictions that Mr. McCaleb cites to in his brief. Do this through the rulemaking process, not by finding a constitutional requirement where this court and the United States Supreme Court, and I'm not aware of any other courts that have found a constitutional requirement of this type. As such, I would just ask this court to follow its past precedent and to affirm the decision of the 8th District Court of Appeals in this matter. If there's any other questions, thank you.
Thank you. Mr. McCaleb, you've used your time. You may take a minute.
Thank you, Your Honor. And I'm sorry I disconnected earlier. I'm not sure what happened. So just a couple of very quick points. First of all, the potential conflict in a package plea deal comes from the attorney's motivation to help client B by getting client A to plead. And that motivation may come completely separate from the actual culpability of those, either defendant, or the strength of the government's case. That's the possible conflict. And as to possible conflicts, the government says that the trial court needs to be apparent, or it needs to be obvious that an actual conflict exists. And that's simply not true in order to demand an inquiry into the existence of a possible conflict of interest. And that's what didn't happen here. There was no inquiry into the possible conflict of interest raised by the dual representation.
Well, counsel, where would you, when would you, I'm presuming you're ideally, you'd like to have a judge make that inquiry anytime there are multiple defendants, 2 or more defendants represented by the same attorney, okay? Would you extend that to the same attorney's firm if the multiple attorneys, but they all belong to the same, which is not uncommon, a group of, attorneys doing primarily criminal work. I'm just, maybe don't answer that because it doesn't really matter. But the other thing, at what juncture would you impose this on the trial court?
Well, first, I will answer the question as to the whole firm. I think a firm is generally considered, one sort of attorney in the abstract sense for most ethical purposes. I think it would apply to the entire firm. As to when, it should be as soon as possible after the trial court knows or should know, which that dual representation is occurring, which I think in this situation would be no later than the first true pretrial. It could be earlier at arraignment or something like that. It depends, but certainly by the first pretrial and almost certainly not very much later.
Okay. All right, thank you.
I have a question. Counsel, do we have to overrule Manross to reach your result?
Well, in a way, yes, but in a way, no. This court has been retreating from Manross, I think, for a long time. It's barely mentioned in Gillard or Dillon. And when you synthesize together Gillard and Dillon, as I think, or as I'm suggesting that you should in this case, there's not really any way of reconciling what Gillard and Dillon say together with what Manross says. And then on top of all that, I think Manross is incorrect in leaving this to the attorney alone, given that the way conflicts of interest work, that there's a very high risk that they're going to hijack the very judgments needed to take advantage of what you could call the best position. I mean, not to get too philosophical, but being in the best position in this case, which I think means close to the facts, can also actually make you be in the worst position because you can't use them because of the conflict you're facing. So I do think, this court hasn't really talked too much about Manross in the times that it's made decisions in this area afterwards. But I think at this point, Manross either is no longer good law because of prior decisions, or that this court should say that it is.
Thank you. Thank you, gentlemen. We'll take the matter under advisement and you will be notified of our decision. Marshall, will you please adjourn court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.